Hi, today I want to talk to you about interlocutory applications. So you see, interlocutory applications are just applications that are made to the court during the pendency of a suit. Now, what does that mean? When we talk about the pendency of a suit, we're talking about while a suit is before the court. So between the time from when the suit is brought and when the judgment is given, from time to time, parties may wish to make certain requests to the court. And the way they do this is by bringing applications. And of course, applications are brought to the court by filing motions. So the applications that are brought to the court between the time a matter is instituted and when judgment is given is referred to as interlocutory. As the name implies, inter, that's between, and locutory, that's talking about the speeches of the parties. Now, the person who makes the application is called the applicant, and the other party or parties are referred to as the respondents. Now, there are two ways by which these applications are made to the court. Now, one is by motion on notice, and you can see that on the screen, and the other is by motion ex parte. Now, when we talk about motions on notice, you see that a motion on notice is an application that is brought and notice is given to the other party or parties in the suit. Now, this is basically because if you think about it, the system of litigation and the system of administration of justice requires fairness. So if I am asking the court for something, it's only proper that you, the other party in the matter, should be made aware of what I'm asking the court for, all right? Because you know that it's fundamental that in a suit, the court must be seen to be an impartial arbiter and that both sides must always have the opportunity to be heard. And so that's what motions on notice are. They're applications that are brought to the court and notice is given to the other party so that they also have a right to respond, a right of reply. Now, motion ex parte, on the other hand, if you just listen to the name ex parte, that's like excluding the other party. So this is a motion, an application that is made to the court in the absence of the other party or without giving notice. It excludes the other party. Now, why should this be? It doesn't seem fair. Well, you find out that motions ex parte are used in circumstances where the interest of the other party would not be affected by what you're seeking from the court. For instance, if what I'm asking the court for is purely administrative, let's take, for example, if there's been a misspelling of my name as a party in the suit and I just wanted that amended, I don't need to give notice to the other party about that application. Why? Because it doesn't affect his interest. Having the right spelling of my name put in the court proceedings would not affect his interest in the suit. So that's the sort of application I could make ex parte. You would also find out in some other topics that we do in civil litigation that they are also used in cases or in situations of extreme urgency or emergency, all right, where any delay could cause irreparable loss or damage, all right? Because you know that when notice is given to the other party would have time to reply. Now, if there's so much urgency to your application, if there's so much, if it's an emergency that requires a lot of haste, then the court may take that application ex parte and subsequently hear the same application on notice. So I hope you've learned a bit about motions today. I'll see you another time.